This is Barry Zalma, Zalma on Insurance. Today announcing Zalma's Insurance Fraud Letter, Volume 25, Issue 19, to be published October 1, 2021. On October 1, 1979, 41 years ago today, I left the world of the employed and became an entrepreneur by opening my own law firm. The law firm was incorporated shortly thereafter as Barry Zalma, Inc. When I opened for business on October 1, 1979, I had no clients and no certainty that I would have any in the future. I had borrowed money from the bank to carry me through the first 6 months and was concerned about my ability to pay the loan with my third child about to be born. Much to my surprise and pleasure, on October 1, 1979, at 8:10 a.m., the best claims handler in the London market, Alan Warboys, called from London and provided me with my first case as an independent lawyer to represent certain underwriters at Lloyd's, London. He and the Lloyd's underwriters he represented showed faith in me as a lawyer and as an insurance expert. Alan is now and will forever be my law firm's first client and is still and always will be a good friend. He's retired from the market now, as I am retired from the practice of law. Although I did retire from the practice of law, I still work an 8-hour day, 5 days a week as a consultant, author, blogger, and video blogger. I was admitted to the California bar on January 2, 1972. I practiced law in California full-time until I retired from the practice of law in 2015. To those of you, in addition to Alan, who have honored me by retaining me as your lawyer, thank you for a long, productive, and successful, I hope, legal career. In 2015, I asked that the California bar render my license to practice law inactive, and it agreed. I limit my work to acting as an insurance claims handling, insurance fraud, and insurance bad faith consultant, expert witness, educator, and author. I am not retired. I am only retired from the practice of law. I am fully recovered from open heart surgery and continue to work 5 days a week. I am only slowing from my time as a lawyer by limiting my work to consulting and testifying as an expert. I am presently 79 years old and feel as strong and healthy as I was when I was 40, maybe even better. I used that expertise last year when I testified in an Idaho trial court for a policyholder who was not treated well by his insurer and who received a favorable verdict from the jury. I keep busy helping lawyers, both for insurers and policyholders, deal with difficult insurance issues. Most of the cases for which I am retained as a consultant or expert are resolved by settlement, often shortly after my report to the court is published, and I am rarely required to testify at trial. I expect to continue working, using my 54 years of experience in the insurance claims industry, forever, or at least until I reach the century mark my mother reached before she passed away. I will continue to publish twice a month Zalma's Insurance Fraud Letter and will publish daily articles at https://zalma.substack.com, to my blog Zalma on Insurance, which digests recent insurance law cases. I have now made available for anyone interested in being a claims professional a complete insurance claims library available as both paperbacks and Kindle books at Amazon.com, where I have already published Zalma on Insurance Claims, Construction Defects and Insurance, Zalma's Mold and Fungi Handbook, the Homeowner's Insurance Policy, the Law of Unintended Consequences and the Tort of Bad Faith, Insurance Fraud, the compact books of adjusting property or liability claims, and several other books, including from Thomson Reuters, the 13th edition of the Property Insurance Investigation Checklists, from the American Bar Association, and from Full Court Press, several books on insurance and insurance claims handling. At the present time, I have also published to YouTube and Rumble.com more than 285 free insurance law and insurance claims handling videos, just like the one you're watching now. I will continue to serve as a claim handling and bad faith consultant, expert witness, author, educator, arbitrator, or mediator. Since my firm has been reduced to only me, I will always answer the phone or respond to your inquiries by telephone, email, or even via the U.S. Postal Service. The October 1, 2021 issue contains an article on the examination under oath as a tool and as a serious and important part of an insurer's investigation. The attorney, insurance claims professional, or investigator who conducts an EUO can take a role similar to the role of a prosecutor without the usual constitutional restraints controlling testimony at a deposition or trial. A false statement as to any material fact during the EUO can cause the policy to be declared void, even if the fact has no relationship to the loss. In the U.S. Supreme Court decision called Claflin, the false testimony concerned a witness that would not affect the amount payable under the policy, but to protect his reputation for veracity, he lied at the examination under oath. The U.S. Supreme Court found that the witness of the injury was material to the investigation and declared the policy void for fraud because he made a false statement under oath. Contrary to the belief of lawyers for the policyholder, the EUO is not an adversary proceeding like a deposition in a lawsuit. The EUO is an investigative tool made available to the insurer. It allows the insurer to delve deeply and under oath into all aspects of the policy and the loss. The testimony to be elicited is not constrained by rules of discovery or the codes of civil procedure. The only restraint on the EUO is reasonableness. Unlimited questions are allowed. Only totally irrelevant and unreasonable questions dealing with facts completely outside the policy, its acquisition, or the loss are not favored, but cannot be eliminated. Irrelevant questions need to be tolerated if there is any possibility the question may lead to an inquiry about facts relevant to the policy or claim. In fact, there are no questions that are irrelevant in an EUO, since each question may lead to more important information that could never have been learned about had not a foundation been led by questions that appear on their face to be irrelevant. Since there are no rules for the taking of the EUO, any question asked is important and must be answered. There is no judge to rule on objections, and no court has the ability to enter into the taking of an EUO. The article in the Zalma's insurance fraud letter for October 1, 2021 goes on at great detail, and I commend it to you to read and understand. I am also reporting about insurance fraud education that I will be making available shortly. My presentations are practical, thought-provoking, sometimes entertaining, and will fit easily into any insurance company or insurance adjusting firm's budget. Enthusiastically committed to professionalism in insurance and insurance claims, I prepare training programs that are positive influences on insurance professionals. And my intent is to create a complete excellence in claims handling program that will cover everything needed by an insurance claims professional dealing with property or liability claims. Please follow me at my website, at my blog, and at my Substack publications so that you can learn about the training that will be available shortly. The newsletter, Zalma's Insurance Fraud Letter, also has an article about a man bites dog story where State Farm sued chiropractors for fraudulent claims. Insurers, victims of insurance fraud, are finding little or no prosecution of those who defraud them. State Farm, not willing to wait, proactively sued defendants James Marshall, Doctor of Chiropractic, and Marshall Chiropractic, LLC, for fraud. After discovery was completed, the chiropractors moved for summary judgment seeking dismissal of State Farm's suit. The United States District Court was asked to dismiss because State Farm failed to file an affidavit of merit asserted against the chiropractors required of malpractice suits in the state. Plaintiffs, State Farm, are auto insurers who provide personal injury payment, PIP coverage, to their insureds. The defendant is a chiropractor licensed in the state of New Jersey and the owner of Marshall Chiropractic. Plaintiffs sued the chiropractors, asserting 4 causes of action: common law fraud, breach of the New Jersey Insurance Fraud Prevention Act, unjust enrichment, and declaratory relief. According to the complaint, the defendants fraudulently acquired PIP payments from plaintiffs by imposing a predetermined treatment protocol and subjecting State Farm insured patients to virtually the same laundry list of services on nearly every visit, rather than conducting an individualized assessment and creating a personalized treatment plan, plaintiffs demanded reimbursement for PIP benefits totaling approximately $850,000, plus treble damages cost declaratory relief as redress for the misconduct. State Farm and other insurers that proactively sue the persons and entities they believe are defrauding them have found that taking money from fraudsters is more effective than the rare prosecution by the state of the fraud perpetrators. As victims of fraud, any insurer has the right to be indemnified from the fraudsters and, more importantly, take the profit out of the crime. Waiting for a state prosecutor, especially with some prosecutors who are averse to even prosecuting serious criminal atrocities like assault, battery, and murder, it is time that all insurers, if their SIU develops evidence that they are being defrauded, should proactively file for damages under the state fraud statutes, the federal RICO or state RICO statutes, or under the KETAM whistleblower laws filing on behalf of the state. Zalma's insurance fraud letter also publishes good news from the Coalition Against Insurance Fraud, listing multiple cases of convictions of insurance fraud perpetrators. In addition, there's an article about the cancellation rule that requires contradictory evidence to be ignored, and finding that there is a problem with lying to your insurer. A listing of health insurance fraud convictions, usually by prosecutions by the U.S. Attorney's Office for defrauding Medicare and Medicaid entities. A listing of other insurance fraud convictions that are not related to health care, such as murder for insurance money. Links to the last 10 blog postings, and information from the Insurance Claims Library. If you found this video to be of interest, please pass it on to your colleagues. It's free. And please also subscribe to Zalma's Insurance Fraud Letter, the YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can learn of future videos, future blog posting. And I would appreciate if you click on the like button on the YouTube channel and the Rumble button on the Rumble channel. Thank you for your attention.